Hello friends, myself Nitin. I will be discussing on the topic overview of CPC and various stages of a civil suit, where I will be covering two types of laws, that is substantive and the procedural law, judicial process which we follow in India, adversarial or inquisitorial system, the hierarchy of civil courts in India, the scheme of the CPC, Code of Civil Procedure, essences of a civil suit, and the last and the most important, various stages of a civil suit from the first day till the last day. Starting with the first point, that is the types of laws. The laws are broadly of two types, substantive law and the procedural law. Substantive law confers powers on the court and determines the right, duties and the liabilities of the party to a particular suit or proceeding. Whereas procedural law prescribes the procedure and the mechanism to enforce the rights and duties which are created by the substantive law. Generally, we consider that procedural law is subservient to substantive law, but the efficacy of substantive law is largely dependent upon the efficient procedural law. Unless until the procedure is simple, expeditious and inexpensive, will not be able to achieve the desired objective of the substantive law. Hence, substantive and procedural law both are complementary to each other and are interdependent upon each other. Without an effective procedural law, however good might be the substantive law, it will be ineffective, will be meaningless. Now come to the applicability, whether substantive and the procedural law are applied retrospectively or prospectively. Generally, substantive laws are applied prospectively, whereas procedural laws are applied retrospectively. Now further dividing substantive law into two, civil substantive law and the criminal substantive law. By default, civil substantive laws are applied prospectively unless and until it is expressly stated in the statute that it will apply retrospectively. Whereas substantive criminal laws are always applied prospectively, because the legislature does not have the competence to apply it retrospectively, because it will be hit by Article 20, Clause 1, that is ex post facto law, violating the fundamental right of the accused, except in case of beneficial statute. Now coming to procedural law. Procedural law are generally applied retrospectively unless and until expressly stated in the statute that it will apply prospectively where it hit upon certain substantive provisions in the procedural law. Now coming to the last point is the interpretation. Substantive laws are interpreted strictly, literally, to give effect to the intent of the legislature, whereas procedural laws are interpreted literally to give maximum benefit to the litigants. Now coming to the topic, adversarial and the inquisitorial system, the two judicial process. In India, we follow adversarial system. Now what is your adversarial system? Adversarial system, mainly we can discuss adversarial and the inquisitorial system on very point of scale, like the standard of proof, the conduct of the trial, the role of the judge, investigation and the discretion of the prosecution, the role of the victim and many other. In adversarial system, the court acts as a referee between the two contesting parties. In civil, the two contesting parties are the plaintiff and the defendant, and in criminal cases, the two contesting parties are the prosecution and the defense, the accused. So it is an entire contest where both the parties try to prove the fact, and the court acts as a neutral referee, unbiased person. Whereas in an inquisitorial system, the court actively participate in the judicial process, where he monitored the investigation and to achieve the ends of justice. Now coming to where it is followed. Traditionally, the common law countries follow adversarial system, whereas the civil law countries follow inquisitorial system. Now in adversarial system, we have two sources of law, and in inquisitorial system, we have one source of law. Now the one source which is common across, that is the legislature who have the primary duty to make the law. So in adversarial system, there is two sources of law. One is the legislative law and the other is the judgment law, which is a judicial precedent. Whereas in inquisitorial system, there is only one source of law, that is the legislative law. The judicial precedent does not have a binding effect on the subsequent cases. Therefore, in inquisitorial system, the legislature has to be on toes to meet the changing needs of the society, to make the law dynamic. In adversarial system, the judge-made law make the law dynamic and not the static, to meet the changing needs of the society, to meet the pace of the society. Now come to in India, as I have already stated, in India follow adversarial system. But what will be the best answer? In India we follow adversarial system with certain inquisitorial powers conferred on the judges for the sake of attainment of justice. So if you see in CPC, CRPC or evidence, everywhere, as and when it is required, the discretion is conferred on the judges that they can intervene for the sake of justice. They can actively participate for the sake of. So in India, primarily we follow adversarial system with certain inquisitorial provisions for the sake of attainment of justice. As attainment of justice is the ultimate aim and the goal which we have to achieve. We have to make an endeavor to achieve. Now coming to the next point, the topic, that is the hierarchy of criminal courts in India, civil courts in India. Now in India, we have independent and integrated judiciary. Now independent means without any interference from the executive or legislature, which we have borrowed from US. Wherein integrated judiciary, that means we have a unified legal system which we have borrowed from Government of India Act 1935. Now independent and integrated. So now we have three layers: Supreme Court as the apex court at the top, then in the state the High Court, and below that the district judiciary. So we have three layers: Supreme Court, High Court and the district judiciary. Similarly, within district judiciary again there is a three layer: Court of District Judge, which also include additional district judge. Below that the Court of Civil Judge Senior Division, and below that Court of Civil Judge Junior Division. And there is also a court of small causes, which I have not put in the hierarchy. It is given, a power has been conferred under the Small Causes Courts Act to the state government, as and when they feel necessary, desirable, they can establish the Small Causes Court to try the matter of small value in a summary manner. So I have not put, so there is a three layer: Supreme Court, High Court and then District Court, and within District Court again there is a three layer for the ease of understanding and to remember. That is District Judge, Court of Civil Judge Senior Division, which we also commonly call them Sub-Judge, and Civil Judge Junior Division, which we also commonly call them Munsifs. So these three. Now coming to the next, that is the scheme of the code. Now as we have a general notion that, now we are coming to CPC. Now this I have given you the background. Coming to CP, the scheme of the code. CPC is considered to be complex, as we are not able to understand or synchronize the two parts, that is the sections, 158 sections, and the rules which contain the 51 orders. So the scheme of the code lies that it is broadly divided into the body of the code and the rules. Body of the code contains 158 sections in 11 parts, where the rule contains 51 order in the first schedule. The body of the code is a substantive part of CPC, whereas the rule is the procedural part of the CPC. Now substantive part can be amended only by the legislature, who have the primary role and the power either to enact the law or to amend the existing law. So the body of code can only be amended by the legislature, that is 158 section in 11 parts, where the rule which contains 51 orders can be amended by the respective high courts as well, in addition to the legislature. Now why such provision was made and why that this is the unique feature of CPC? To attain certain flexibility, because the high court or the state government is in a better position to understand the local needs and the requirement. So to give certain flexibility, the high court has also been conferred with the power to make the rules, but that can come into force by way of gadget notification once approved by the concerned government, which has been prescribed in the rules from 122 onwards. Now with this, and then there is appendix in the first schedule, that A to H. Now let me bring to your notice that there are all the forms also which is annexed at the end in the appendixes, so you don't have to travel anywhere for anything. There are few major amendments which took place, that is 1976, 1999, 2002, 1999, 2002 both came into force in 2002, then 2015, and the latest is 2018. 2015 and 18 mainly deal with the commercial code for speedy disposal of cases. Now coming to the essentials of a civil suit. For a civil suit to exist, what are the essentials? There are four essentials. there must be opposing parties. There must be opposing. For any suit, there must be two parties. Can you file a suit against yourself? No. So there must be minimum two parties, two opposing parties. Second, there must be a cause of action. Cause of action in brief, in simple word, when the dispute arose. When the dispute arose. Third, the subject matter in the dispute. What is the subject matter in which you have a dispute? And the last, the relief claim. So these are the four essences. Again, repeating the same: opposing parties, cause of action, which means when the dispute arose. Now this is also important for the purpose of calculating the period of limitation. Then what is the subject matter of the dispute? And the fourth, what is the relief which you are claiming, which the court you are seeking the court to give those relief. Now coming to the last part of the today's lecture, that is the stages of a civil court. Now this is, I will take you practically, would be how once the person becomes aggrieved, once the cause of action arises, till the final you are getting the relief from the court of law. So I have divided the entire stages of a civil suit into four parts. The first is the pre-institution phase, second is the institution phase, third the trial phase, and the fourth the post-trial. Now the pre-institution. Now institution, let me explain you the term institution. Institution means you are approaching the court of law. But are you a legal expert? Do you think that you will go to the court of law and you will be entertained directly? No. So for going to the court of law, you need certain advice. So if you feel aggrieved, if you are aggrieved, you approach to a legal expert. And who is a legal expert? The advocates. Now what happens when you go to the advocate? You narrate your entire facts, your claim, and what you are expecting in such circumstances. Now what is the duty of an advocate? He will understand the fact, will jot down the facts, then he will evaluate all the evidences, oral or the documentary evidence which you are. Then he will make an analysis of the potential lawsuit, and then he will propose that what are the possibilities in the instant case. After analyzing the fact and circumstances of the case, evaluating the evidence and the cost benefit analysis of the potential lawsuit. So after doing this and applying the law to the present fact, he will propose you whether to go for an ADR, whether to go for a regular litigation, or any other approach which he may suggest, which must be best suited to you. But you might be expecting certain things, whether or not you will be able to get that relief from the court of law. That is the very important matter. Now if you have made up your mind and if you said that yes, I want to go to the court of law in any circumstance, then he will explain you what are the complications and what are the requisites and what are things you will face in the court. So the time, privacy, the possibility of collecting the fruits of the judgment. Then he will calculate that what is the period of limitation, whether your suit is within the period of limitation. If the answer is yes, according to the Limitation Act, if it is well within the period of limitation, then he will carry out the legal formalities for the purpose of drafting the plaint. That is, who will be the parties to the suit, against whom you are bringing the suit, you are seeking the relief, jurisdiction, where the suit will be filed, what is your claim, and what is your relief which you are expecting, which will be mentioning in the prayer clause. So after this, the advocate will come up with a legal document on behalf of the plaintiff, which is known as the plaint. Plaintiff is the one who institutes a suit by way of presentation of plaint. So with this we have completed the pre-institution phase, which takes place in the lawyer's chamber, who represent you in the court of law on your behalf, as you are not a legal expert. So once this legal document, that is a plaint on behalf of the plaintiff, is ready, then you will approach the court of law. And once you approach the court of law, you institute the suit by presentation of a plaint. Now once the plaint has been duly admitted by the court, then it will be duly numbered, and then you will be asked, then the court will order for issue and service of summons to the defendant. Now once the court have issued the summons, within 30 days of the institution of a suit, the opposite party have to file the written statement, which may be in form of a reply, set off, or a counterclaim, within 30 days, extendable to 90 days. In commercial dispute, it is 120 days. Now once the written statement is filed, if any it is desirable, you can file the additional pleading also, which may be in form of a replication or a rejoinder. Now once the summons is issued, a date is fixed in the summons for appearing before the court of law. So the first step is institution of suit by presentation of plaint. Second is issue and service of summons. Third is filing of written statement in form of a reply, set off or counterclaim within 30 days, extendable into 90 days. Then fourth, the parties will appear on the date which is specified or mentioned in the summons. So on the date fixed, which is called as the date of first hearing, both the parties are in attendance before the court of law. Now, what is the object and the purpose of the first hearing? Object and the purpose of the first hearing is to find out the dispute. What is the dispute between the parties? Which we in legal language we say the settlement of issues, framing of issues, and it is the duty of the court to settle the issues. Now, this is the date which is fixed for first hearing, but there might be certain possibility that the parties have appeared, both the parties appeared, one the party appeared, then there is a consequence attached to it. So now, if both the parties appear, the suit will proceed and the court will fix the date for framing of issues. Once the issues has been framed, but at the time of framing the issues, court will go into the pleading bare perusal. If the court feel, then there are certain tools in the hand of the court for the purpose of framing the issues, like examination of parties by the court if the court feels desirable, discovery, inspection and admission of facts or documents by the court or by the parties, production of document by both the parties, and if the court feel this is a matter which can be resolved through ADR, court can refer the parties for ADR mechanism depending upon the nature, but that is not mandatory, neither for the court nor for the party. So this examination, discovery, production, settlement, these are the tools in the hand of the courts for the purpose of properly framing the issues. Because sometimes we are supposed to disclose the material fact, but if we have not disclosed, so for the purpose of understanding what is the real dispute, court exercises the powers, these tools to understand, so that court can frame the issues properly. So it is the first hearing, but it takes a lot of adjournment for properly framing the issues. So by framing the issues, the institution phase comes to an end, and the trial phase begins. As soon as the issues are framed, within 15 days, both the parties are supposed to file the list of witnesses, and then the summons are issued to the witness. Now, once the list of witnesses is filed, who will have a right to begin? Generally, the right to begin is with the plaintiff. Why the plaintiff? Because the plaintiff has the burden to prove. As he have raised the allegation, he have to discharge his burden. And what is the standard of proof? Preponderance of probability. So opening statement, right to begin by the plaintiff to discharge its burden. So there will be plaintiff evidence, first examination chief on affidavit, then cross and re-examination of plaintiff witness in open court. Once the plaintiff evidence is closed, then the defendant will lead his evidence, examination in chief on affidavit, then cross and re in open court. Now once the evidence for the plaintiff and the defendant is closed, then there is a date is fixed for final argument, where you will orally argue before the court of law, summarizing how you have appreciated the fact and circumstances and what are guiding the court. You can also submit the written arguments, so oral and written, but you will not get any additional time for submitting the written arguments. So once the argument is closed, this leads to conclusion of the trial. Once the trial is concluded, the court is mandated, is duty bound to deliver the judgment within 30 days, extendable to 60 days in exceptional circumstances from the date of conclusion of the trial. So once the judgment is pronounced, and if you feel aggrieved, now you are in the post-trial phase. If you feel aggrieved, then you have various other options. Now in civil cases, once the judgment has been pronounced, the court is supposed to draw a decree within 15 days of the pronouncement of judgment. But the decree should bear the date of the judgment. Now, once the judgment and decree is passed, if you feel aggrieved, either partly or fully, you have an option. You can either go for an appeal, or if appeal is not allowed, you can go for revision or review. Review before the same court within 30 days, appeal before the district court 30 days, or if high court, depending upon the pecuniary jurisdiction, 90 days. If appeal is not allowed, then revision. As appeal and revision are contrast remedies. Revision only in the high court 90 days, And once the judgment is final by the apex court, by the final court, then execution of decree can be filed within 12 years, or in case of money decree, 3 years. That comes to an end of the entire civil suit from the first day aggrieved till the last day getting a final judgment. Thank you, one and all.